He does not deserve armed royal protection. The principle of it's horrible because he's left the United Kingdom, he's relinquished his royal duties, and he's spent the last few years attacking the monarchy and the United Kingdom and the royal family.
More than 100,000. That is the figure that emerged from High Court testimony this week, and it landed like a grenade in the middle of Harry's lawsuit against the Daily Mail's publisher. Researcher Graham Johnson confirmed under oath that he paid that sum to 6 individuals whose claims are central to the Duke of Sussex's legal case against Associated Newspapers Limited. 6 people, all of whom, the court heard, coincidentally feature in the very allegations Harry is making against the tabloid giant. Coincidentally. That word hung in the courtroom air with all the subtlety of a fire alarm. Having followed this story for years, I have watched Harry wage war against the British press with the fervor of a man convinced he is fighting for justice. He presents himself as David against the Goliath of Fleet Street, a crusader determined to expose the dark underbelly of tabloid journalism.
The king does not want to be involved in this. It's legal jeopardy. And also, of course, the king simply doesn't, he's simply too exhausted to have time or energy to deal with the ongoing sagas surrounding Prince Harry.
But this week, the courtroom revelations painted a very different picture. When your key witnesses have been paid large sums by a researcher working on your side, the question stops being about what the newspapers did. The question becomes whether the evidence against them was purchased rather than discovered. The stakes here are enormous, and they extend far beyond Harry's personal grievances. This is a man who walked away from his family, his country, and his duty to pursue what he calls accountability. He has built his entire post-royal identity around being a truth-teller, the one who will drag media corruption into the light. If the foundation of his legal case crumbles under the weight of paid testimony, everything he has sacrificed could appear less like principle and more like petulance. The High Court proceedings are ongoing, and what emerges next could determine whether Harry's crusade has any legitimacy left at all. Let me walk you through exactly who received money, and why it matters so much to the integrity of this case. The largest payment went to Gavin Burrows, a private investigator who received $75,000. Burrows is not a peripheral figure in this legal drama. He is the man who made the most explosive claims about phone hacking, landline interception, and bugging. His allegations form the backbone of some of the most serious accusations Harry has made against the Daily Mail's publisher. Without Burrows, the case loses significant force. Here is where the situation shifts from concerning to potentially catastrophic for the Duke. Burrows has now stated that his witness statement is completely false, not partially inaccurate, not taken out of context, completely false. He also claims that his signature on the statement was forged. The man who was expected to be a key witness has effectively discredited his own testimony and stepped away from it entirely. The court also heard about payments to Glenn Mulcair and Greg Muskew, both convicted phone hackers. Mulcair received £22,000, while Muskew was paid £12,000, with the payments made between 2015 and 2021. These are not neutral bystanders who happen to have useful information. These are men who went to prison for illegal phone hacking. Their involvement cuts both ways. Yes, they have insider knowledge of tabloid misconduct, but they also have a clear incentive to tell a paying party exactly what that party may want to hear.
This is about his safety. I don't think that is what this battle with the UK government and the Home Office, I think it's about his ego.
Steve Whittemore rounds out the rogues gallery of paid sources. He was convicted of breaching information laws back in 2005. Yet Harry's team apparently considered it appropriate to pay him £5,000 in 2021. Daniel Portley, a US-based private investigator, received £6,000 for work on a book, along with additional funds for access to his archive. Christine Hart, another private investigator, also received £5,000 from Johnson. The pattern is difficult to ignore. One individual after another with questionable backgrounds received substantial payments, and one after another now features prominently in the legal case against Associated Newspapers Limited. From what I have seen, this is not what building a conventional legal case looks like. It resembles the assembly of a network of paid contributors whose role is to provide damaging claims. The question every observer must now consider is straightforward. When someone is paid £75,000 and their testimony then appears in your lawsuit, are you receiving the truth, or simply what you paid for? The answer to that question lies in following the money, and the trail leads to some unexpected places. Much of the funding for these payments came from Max Mosley, the late multi-millionaire privacy campaigner who spent his final years fighting tabloid intrusion. Mosley had his own reasons to resent the British press after they exposed aspects of his personal life that he would have preferred to keep private. His financial support for anti-tabloid efforts continued even after his death, with funds distributed through a company linked to his estate. The man may be gone, but his money continued to support the fight against the newspapers he deeply opposed.
And I think that's actually what the armed cops is about. I think it's his ego. It's humiliating for him to come to the UK and not have those cops.
Additional funding came in the form of what was described as a loan from Evan Harris, a former Liberal Democrat member of Parliament and a prominent figure in Hacked Off, the campaign group dedicated to media reform. Harris is not a neutral figure who simply had spare funds available. He is an activist with a clear stance against the tabloid press. When loan money from an anti-tabloid campaigner is used to fund payments to individuals who then provide anti-tabloid testimony, the appearance of coordination becomes difficult to ignore. The specific payment structure to Gavin Burrows warrants particular scrutiny. Johnson paid him £25,000 for what were described as extensive notes and commentary. In addition, Burrows received £5,000 per month for 10 months as part of an agreement to work on a memoir. That amounts to £75,000 flowing to a single individual, framed as research fees, book contributions, and consultancy work. The financial structuring would raise questions for any careful reviewer. What emerged from the court testimony is a picture of ongoing financial relationships between an anti-tabloid researcher and the very people whose claims would later underpin legal action. These were not one-off transactions. They were continuing arrangements that created financial dependence. When someone's income depends on a party seeking damaging information about newspapers, the incentive to provide such information becomes significant, regardless of whether it fully reflects reality. Associated Newspapers Limited has maintained its innocence throughout the proceedings, describing the allegations as preposterous and insisting that its reporting relied entirely on lawful journalistic methods. Whether that defense holds up remains to be seen, but the disclosure of these payments has given the Daily Mail's legal team a powerful line of attack: the credibility of the evidence itself. Anthony White, the barrister representing Associated Newspapers Limited, challenged Johnson directly during the High Court hearing. White suggested there was a pattern of payments, or promises of payments, to individuals in exchange for evidence that could be used against Associated Newspapers and the tabloid press more broadly. This was not a passing remark. It amounted to an allegation that the evidence-gathering process itself had been systematically influenced. White argued that it appeared to be Johnson's modus operandi to investigate unlawful information gathering by paying individuals who could provide potentially useful material. The concern he raised goes to the heart of investigative integrity. When sources are paid, bias can enter the information stream. Someone receiving regular payments has a strong incentive to ensure those payments continue. The way to do that is to keep producing material the payer finds valuable. In such circumstances, accuracy can become secondary to usefulness. Johnson was also confronted with his own email in which he appeared to urge Mulcair to raise his game. That phrase is revealing. It does not sound like the language of someone passively receiving whatever information a source chooses to share. It suggests pressure for more, encouragement to deliver stronger or more impactful material. That, in turn, raises concerns about active shaping of the evidence rather than neutral documentation of facts. Material obtained through these various financial arrangements now forms a significant part of Harry's legal case against the Daily Mail's publisher. That connection is what makes the revelations particularly serious. There is a clear difference between paying sources for background research that informs journalism and relying on paid material as evidence in active litigation. The boundary between research and influence begins to blur in uncomfortable ways. Watching this unfold raises a broader question: did Harry's legal team carry out sufficient due diligence on the origins and reliability of the evidence supporting their case? Did they know about these payments? Did they ask? The answers to those questions matter enormously in understanding Harry's role in this situation. Is he the victim of overzealous allies who cut corners? Or was he aware that the case being built on his behalf relied on paid testimony? Neither possibility reflects well on a man who presents himself as a champion of truth. Graham Johnson mounted his defense in court, but his explanations raised as many questions as they answered. Johnson argued that the payments were made for journalistic purposes, not to secure witness evidence. He stated directly that he never paid for testimony used in legal proceedings. He also said he sought legal advice multiple times, including written guidance, and that he acted in accordance with that advice. On the surface, this is the defense of someone who believed he was operating within proper boundaries. The difficulty is that the court can draw a direct line between the material Johnson paid for and the evidence now being presented against Associated Newspapers Limited. The information did not remain within journalism. It moved into litigation. Whether Johnson intended that outcome or not, the effect is the same: paid sources became witnesses, research became evidence, and the boundary between journalism and legal action blurred. Johnson also pointed out that he had written numerous articles on the subject and had placed interviews with some of the paid sources on the BBC's Panorama and other outlets. He argued that he revived what he described as a dead story and brought it back into public attention. That framing casts him as a journalist pursuing an important issue. What it does not resolve is the central concern: whether paying sources compromises the reliability of the information they provide, regardless of the purpose it ultimately serves. The distinction Johnson attempted to draw between paying for research and paying for testimony may not hold up under legal scrutiny. Lawyers for Associated Newspapers Limited appear prepared to argue that the paid material flowed directly into the current case. If they succeed in establishing that link, Johnson's claims about journalistic intent may be seen as semantic distinctions that do little to address concerns about evidentiary integrity. What stands out is Johnson's confidence in his own conduct. He does not appear to view the payment arrangements as problematic. That confidence may reflect a genuine belief in the importance of his mission, or it may stem from operating for years in an environment where the perceived ends justified the means. If exposing tabloid misconduct was seen as sufficiently important, questions about how the evidence was gathered may have been pushed aside. This is not the first time Harry has faced uncomfortable scrutiny over the strength of his claims against the British press. The Mirror Group newspaper's case a few years ago offers a telling precedent. Harry alleged phone hacking and took the witness stand to support his claims. During cross-examination, defense lawyers repeatedly demonstrated that information he believed could only have come from hacking had, in fact, been reported elsewhere days earlier. In some instances, the material could be traced back to Harry's own public statements, including comments provided to the Associated Press. Again and again, he asserted that specific details must have been obtained illegally. Again and again, the defense produced evidence showing legitimate sources. His confidence met the reality of documented public records. The pattern that emerged was one of assumption presented as certainty. Harry believed he had been hacked and felt deeply wronged by tabloid coverage. But belief and proof are entirely different matters. Emotional conviction about wrongdoing did not translate into evidentiary proof of specific illegal acts against him. Now, a similar dynamic appears to be unfolding in the Daily Mail case. Harry is convinced he was wronged. His legal team assembled what they believed was strong evidence. Yet the foundation is showing signs of strain. Burroughs now claims his statement was false and forged. Johnson acknowledges making substantial payments to sources. A case that appeared solid on the surface is beginning to show structural weaknesses underneath. Across both legal battles, a consistent pattern emerges. Harry appears to conflate a broader grievance against tabloid journalism with the far more demanding task of proving specific, legally actionable wrongdoing by particular publications. He knows the tabloids treated him harshly. Of that, there is little doubt. But recognizing that the press was often cruel does not automatically mean that every specific allegation he makes is supported by evidence. The Mirror Group case demonstrated that some of Harry's claims did not always withstand detailed scrutiny. The Daily Mail case may now be revealing a similar vulnerability, but from a different direction. The consequences of these legal battles extend far beyond the courtroom. They reach into family relationships that may prove difficult, if not impossible, to repair. King Charles is reportedly frustrated by Harry's continued legal actions against the press. According to multiple royal commentators, the monarch wants complete distance from any ongoing litigation. That places him in a difficult position when his own son remains closely tied to repeated court proceedings in Britain. Each time Harry returns to London for a hearing, the palace must carefully manage how to avoid any appearance of institutional involvement in a case that could reflect poorly on the monarchy. The situation becomes even more delicate given that a former Daily Mail journalist now serves as Charles's press secretary. The King's communications operation is led by someone who previously worked for the very publication his son is suing. Managing that overlap requires careful handling. Senior royal observers have noted that the sovereign must remain strictly separate from active legal disputes. It is a long-standing constitutional principle that the monarch, and senior working royals, must avoid any connection to ongoing litigation. Harry's determination to pursue these cases places his father in a position where visible support could compromise the monarchy's neutrality. For the institution, constitutional stability must come first. Reports also suggest that Charles is physically and emotionally strained, balancing the demands of the throne while undergoing cancer treatment. Under such circumstances, there may be limited capacity to engage with ongoing family controversies linked to Harry's disputes with the media. What adds a sense of gravity to the situation is the contrast with Harry's earlier public role. He once held a clearly defined position within the royal family, supported causes, and maintained strong public goodwill before stepping away from royal duties. Meanwhile, the High Court proceedings continue, and their outcome may have a significant impact on Harry's remaining public credibility. Associated Newspapers Limited continues to deny the allegations strongly, describing them as preposterous and maintaining that its reporting was obtained through lawful journalistic methods. The publisher has held this position throughout years of litigation. Recent disclosures about payments to sources may strengthen its defense. The company can argue that the case against it was constructed through financially incentivized contributors rather than uncovered through independent investigation. The allegation from Gavin Burrows could be particularly serious if proven. A key figure claiming that his statement was false and that his signature was forged would raise profound questions about the reliability of the evidence presented. Either Burrows is now lying to avoid consequences, or someone involved in building the case engaged in serious misconduct. Neither scenario reflects well on the legal effort Harry has championed. The trial continues, with lawyers for Associated Newspapers expected to draw direct connections between paid research and the evidence currently before the court. If they succeed, the implications could extend beyond this single case. It would suggest that a broader anti-tabloid investigative network may have operated on compromised foundations for years. Material featured in major outlets, including the BBC's Panorama, could face renewed scrutiny. The wider credibility of claims made against tabloid newspapers might also be affected. Harry now faces a difficult reality, depending on how the proceedings conclude. If he loses, his campaign against the British media risks collapsing in the most public way possible. Years spent presenting himself as someone willing to challenge Fleet Street would end in a highly visible defeat. The narrative of Harry as a truth-teller could give way to a perception that he was unable to substantiate his claims despite years of effort and significant resources. But the stakes go beyond a simple win or loss. If the court finds that key evidence was influenced by financial arrangements, the process itself could be seen as compromised, regardless of the technical outcome. Even a legal victory achieved under such circumstances would likely carry lasting questions about credibility. In that scenario, the Duke could secure a judgment while losing the moral authority he has said motivates his campaign. Following this story from the beginning raises a broader question about the path Harry chose after stepping away from royal duties. He once held a clearly defined role. His military service was widely respected, particularly by veterans who saw him serve in Afghanistan. His charitable work connected him to major causes, and his Commonwealth responsibilities gave him an international platform. That structured role is now behind him. He stepped away from responsibilities that carried public expectation and institutional importance. Supporters have argued that the decision was necessary for his mental health. However, his post-royal years have been dominated by disputes, legal battles, and ongoing conflict with the media and his family. Rather than a quieter or more stable life, his public image has often been shaped by controversy and litigation. The contrast is striking, a defined institutional role replaced by an open-ended campaign that frequently generates legal headlines rather than clear long-term achievements. What Harry has described as standing up for himself is increasingly tied to prolonged legal action against the press, a strategy that carries reputational risk, particularly if the supporting evidence comes under question. Meanwhile, his relationships within the royal family remain strained. His father continues to manage the demands of the monarchy while dealing with serious health challenges, and the institution has moved forward without his active role. His former military focus, many of his patronages, and his Commonwealth duties now belong to others. The structure that once defined his public purpose has largely disappeared. In its place is a new public identity shaped by media projects, commercial partnerships, and high-profile legal disputes, a transition that has divided public opinion about his long-term impact. Where this story goes next will depend heavily on what emerges in court. The High Court proceedings continue. Evidence is still being tested. And Harry has effectively placed much of his remaining credibility on the outcome, betting that this time, his claims will withstand full legal scrutiny.